Good morning, Your Honors. Michael Persoon on behalf of the appellants, the Amalgamated Transit Union, Ms. Valerie Jefferson. When I was prepping for this case, I was sitting...
You're going to have to talk up a little.
Sorry, Your Honor. When I was prepping for this case, I was sitting back and thinking, what about it makes it a winnable appeal? What is there that's wrong in the record below where we've got an experienced, knowledgeable, and skilled judge who granted summary judgment against my clients? And what I came back to is the facts of the case. And on the facts of the case, this is a Pickering test case where there's a public sector employee, member of a union, president of the union, who's fired because of her speech to the CEO of the public agency, the RTA. The facts of the case, as presented by the defense, just doesn't make any sense. Now, the key facts are this one interaction between Ms. Jefferson, the appellant, and CEO Mr. Wiggins, one of the defendants. And this all comes on the heels of Jefferson, for the local union, negotiating with the RTA a hurricane pay agreement to make sure that in the wake of one of New Orleans' unfortunately common natural disasters, the public transit agency was up and running. And the bus drivers, including Ms. Jefferson, herself a driver, were here driving people around, getting people where to go. She was working that day on what we call spread shift.
Maybe we know the facts. I mean,
Okay.
Because I was wondering the same question as you. Experienced district judge, what went wrong? Especially when you do look at the context and the form. If she specifically said, I'm off to the board now, didn't say the word bitch, then sure looks like union speech. And
Yes.
I think you're saying there's a fact dispute.
Well,
At least. But here's where I think the district court saw things differently. When the district court in its order says you never challenge the unreasonableness of the investigation, therefore Waters kicks in and courts have to defer to the facts found by the employer, right or wrong. And if that legal regime is correct, then the only fact before us is that your client walked in. Was my friend fired? Answer yes. Bitch. That doesn't sound like it has any public concern or free speech value, right?
partly, Judge.
I mean, I guess the question is, would you agree there's no First Amendment claim or violation if the indisputable and only facts were employee walks in, says, was a friend of mine fired? Yes, and then profanity is uttered. Is there anything of public concern to balance in Pickering?
Just an employee?
Yeah. Was a friend of mine fired? Yes. Bitch. Turns and walks.
No, that's the run-of-the-mill employment.
That's a personal grievance.
Personal employment grievance.
Okay. So then it really does come down to whether Judge Afric was correct that you didn't below, and so I'm looking for a record site, say to him that investigation they did, confirming the CEO's view of what the facts were, was unreasonable.
Let me answer that in a couple of ways, Judge. I'm not going to give you a straight record site to a page and a paragraph, but what I'll do is I'll refer to our statement of facts in opposition to the second motion for summary judgment.
Statement of facts, okay, but what I'd like to see is some reference to Waters in the district court, or even a citation ever, district court or to us, to our Fifth Circuit Salge decision, which I'm assuming you know, but it wasn't in the briefs.
Well, let me back up for a second, because if you look at the facts of the case, Jefferson was acting as the union president, so she's not just employee coming in complaining about it, about her friend.
Those facts exist in the record.
Yes.
But the threshold question is the Supreme Court's Waters analysis. Right or wrong?
Well, remember, even under Waters, it looks to what the employer's reasonable but mistaken belief is.
Yeah.
And it applies that reasonableness test not just to the employer's understanding of the facts, but to the employer's conclusions. That's right there in Waters v. Churchill, pulling that out of Connick.
But you don't dispute that the district court in its findings said, quote, plaintiffs do not dispute the applicability of Waters and Hefferman. Indeed, they make no response to the argument whatsoever.
We disagree with that, Judge.
Okay, you have to be able to point me to something in the record where you told Judge Afric
I'll pull my brief when I'm sitting down and waiting for a rebuttal, Judge.
Yeah.
But what I'd point to is, if you look at, and this is a page around 1895 in the Record on Appeal, it's paragraphs 20 through roughly 28 of our statement of facts opposing the second motion for summary judgment. And remember, Judge Afric originally denied summary judgment finding a fact dispute.
Yes.
And then we'd filed the pretrial order. We're set for a jury trial to go. We were working through the jury instructions, looking at Kinney v. Weaver, looking at body,
Yes.
trying to come up with the charging
And
instructions.
it looks like you've got a body argument.
Yes.
Therefore, Kinney would kick in. But what he says changed between his first order and the second is there's never an argument that the investigation was unreasonable. That's what he's.
But this is what we presented on that in a factual way, Judge.
Okay.
And this is what I was trying to get to at the beginning. Maybe
Yeah.
I took too long. Their story is that Jefferson showed up out of the blue in the CEO's antechamber to his office and just started talking about Thomas Stringer being fired. That's not what happened. That's not a reasonable conclusion, and that's not what's supported by the record.
But we have to accept that story unless you challenge the investigation that concluded that that was the story.
We did challenge that investigation. So look at the facts that we live in. You know, it's September 28th. After she began her midday period from work, Jefferson heard from members and stewards there was a rumor that the RTA intended to renege on the Hurricane Ida deal. She went to speak to Dale Delpit. So she, the union president, who has a legal obligation to enforce the contract she negotiated. That's a legal obligation for a union president. Otherwise, she breaches the duty of fair representation. So she has a real high interest, if you look down the line to the Pickering balancing test, she has a real high interest in making sure that this contract is enforced. She hears a rumor it's not going to be enforced. So she starts to investigate. She goes up the chain of command. She starts talking to Dale Delpit. Delpit says she has to talk to Mark Major. So they call Mark Major. Mark Major refuses to confirm or deny that they were going to honor the agreement. So she goes up the chain of command to Thomas Stringer, the COO at the time.
This is your story, and it looks overwhelmingly a matter of public concern to me. It's all about you. During her union time, she's a bus driver. She wouldn't be walking into the CEOs. I agree with all that. But you know where my problem still is you still haven't said to me where you addressed Waters, number one, to the district court, and number two, am I right? You never cite Salge to us. And that is by far your best authority. Do you know Salge?
Yes, Judge.
Okay, and wouldn't that seem to apply directly?
We cited we chose to cite other cases.
So okay. All right.
And what I'm hearing is you're concerned that we waived the argument.
Yes.
And I didn't see them make that argument that we waived it. I haven't seen a waiver argument appear in their brief.
But that is the linchpin of Judge Afric's ruling. He accepted that there's an issue of fact, applying Pickering, applying Bodie, denies it originally, and then he comes back and says, wait a minute, you're not disputing the investigation, even if factually it looks very, very vulnerable.
Judge, I disagree that that's the linchpin of his ruling. The linchpin of Judge Afric's ruling, again, a very capable judge, was applying the Pickering balancing test. And he says in his brief, in his opinion on page 15, the opinion on appeal, defendants have not indicated that Jefferson's statement caused any other disruptions. Balancing these two weak interests, the court concludes that defendants' interests prevail. This is on page 15. I don't have the record on appeal number. I'm sorry, Judge. I can pull it up if you want.
We know.
Page 15 of the opinion. So that's the linchpin of Judge Afric's opinion, is he assumed that she was speaking as a private citizen, not as a bus driver. He looked at what her speech was as understood by the defendants and then applied the Pickering balancing test. That's the correct legal process to get there. So we weren't contesting that legal process. That's what you do. Where he went wrong was in that balancing test, because when I look at the record, no one has ever explained how Valerie Jefferson, as the union president, coming into the CEO's office in the course of investigating whether the hurricane pay agreement was going to be honored. No one has ever told me how that disrupted the efficiency of the operations. Wiggins himself admitted that there wasn't any interruption to efficiency. That's in the record. We argued that. Now at his deposition, after he's had time to paper everything, after he's talked to his attorneys, he comes up with this statement along the lines of, well, it interrupted the order of management. Well, of course, when a union president talks to the chief executive officer of management, there's going to be some interruption in the order of management. That's just the nature of adversarial relations, of which labor management is one. Lots of times we try to get along and make things work, but the relationship is fundamentally an adversarial
I
relationship.
agree, the portion you cited about Pickering does occur page 13 of his, but the portion I'm drawing your attention to is before that, it's page 11. Defendants argue there's no evidence Wiggins' account of the facts is pretextual. Significantly, plaintiffs do not dispute the applicability of Waters. Indeed, they make no response to the argument whatsoever.
We don't want to dispute the applicability of Waters because Waters looks to what reasonable factual beliefs Wiggins had and what reasonable conclusions came from that. The fact is his conclusions aren't reasonable. His conclusion was that Jefferson showed up out of the blue to complain about Thomas Stringer being fired. That's not a reasonable conclusion. There's also a lot of evidence of pretext. There's shifting rationale. For example, the testimony, and this is all in the statement of facts on the opposing the second motion for summary judgment, was that after the interaction, whatever was said, remember, this is a distance of 20 feet. She's not sitting across from him at his desk. She's in the hallway, the antechamber to his office. That's also in the record. So whatever is said is said. But what happens, she says it, he immediately decides, this is his testimony, he immediately decides it's terminable. He calls legal, some stuff happens. The record isn't that clear on what was done to investigate. What is clear is that Jefferson was called in as a result of that, and before they even had her side of the story, they'd already prepared a pre-printed termination form and gave it to her. And that's our plaintiff's statement of fact in opposition to second motion summary judgment, paragraphs 40, right there. She was then presented with an already prepared termination notice. What kind of reasonable investigation is it where you don't even take a statement from the union president? That's not a reasonable investigation. That doesn't pass muster under Connick, which I was thinking of the later case that applies. It comes back to Connick. So he immediately decides it's terminable, and the reason that he first gave was insubordination. Then when they pre-print her termination form, it's changed to a violation of workplace policy. You know this from Title VII cases. Shifting rationale is evidence of pretext. Another evidence of pretext.
So it's within an hour. He emails saying fire her. The vulgarism used is insubordination. That's equivalent to a threat. Fire her. They print it up. Then before they hand it to her, they say, what's your story? That's basically all.
Yes.
That seems very deficient.
Yes. Yes. There's also further evidence of pretext. So after she's fired, she shows up to a public hearing of the RTA. She's stopped and not allowed to come in. That's in our statement of facts. Plaintiff's statement of facts opposing second summary judgment. Paragraphs 52 through 58. September 27th, 2022, she attempted to attend the public meeting. She was barred. That continued animus, case law tells us, is evidence of pretext in the original decision.
That the hazard pay guarantee from the hurricane was actually in jeopardy, or is it all built on rumors?
It was built on the rumors that she then investigated up the command, from Delpit to Major to Stringer.
So what's the best record support that there was even a rumor of it?
It's Jefferson's uncontroverted testimony, and that's in our statement of facts. So it comes back down to this Pickering balancing test. No one's ever explained how her speech, and remember, this is a prima facie case. The only reason given for terminating her was her speech. There's no Mount Healthy defense. We know Justice Thomas was really concerned about that in the Churchill case. You know, why do we need to have this whole reasonable investigation process when all you need to apply is a Mount Healthy defense? There's no Mount Healthy defense in this case. The only reason they gave for firing her was her speech. And then this speculation, and some speculation is okay, the cases say that, but this is just naked speculation without any explanation anywhere from Judge Afric, from the defendants, as to how her speech actually threatened the operations of the RTA. In fact, Wiggins says the opposite. He says there was no interruption to efficiency of the operation because of her speech. And when you look at the other cases that have applied this, they at least have some facial engagement with that and have some measure of test to say, you've got to explain.
Your policy is the threatening one. That's what it ends up being.
Yes.
That includes disrespect.
Yes, but she's the...
His email said she was insubordinate, and if all it were the word bitch with no connection to unions or employee benefits, that would sound disrespectful, yes or no?
That would be disrespectful, but she was making that statement as the union officer investigating and enforcing her contract. So that gets you, and there's a whole other line of cases that we cited where a lot nastier things get said and it's protected.
Just to follow up on the forfeiture issue, when you're on rebuttal, you're going to provide us a cite to respond to this point by Judge Afric that you all made no response to the Waters argument whatsoever. Do you
Yes.
dispute that? That's clear.
Thank you, Judge.
But we do need some sort of record cite to show that the district judge got that wrong.
I'd like to reserve some time, Your Honors. Thank you.
Thank you, Counsel.
Good morning, Your Honors. May it please the Court, Ross Ledet on behalf of New Orleans Regional Transit Authority, the appellee. While the First Amendment may invest public employees with certain rights, it does not empower them to make a federal constitutional issue out of basic employment matters such as discipline or termination, and that is essentially the case Your Honors have before you. Ms. Jefferson makes a First Amendment claim, freedom of speech and association. I'm going to tackle those points for Your Honors. And my opponent kind of jumped to Pickering, and Your Honor mentioned about the Waters test. I will get there, but if you would indulge me, I'll go through the factors that we dispute. So there's 4 required factors that Ms. Jefferson must prove. To prove her claim, we dispute at least 2 of those, that she spoke as a citizen on a matter of public concern, and those can be broken down even further into citizen and public concern, and then we get to Pickering balancing. But it is important for this court to recognize that you don't even get to Pickering balancing unless you can prove citizen and public concern. We feel that there's enough evidence in the record that she can't even prove that before you even jump to
Judge Afric focused on
Pickering.
public concern. Judge Afric's focus was on public concern.
Correct, Your Honor. And he actually, I put the record site at 1939, he basically assumes, he says, quote, "We will assume that Jefferson spoke as a citizen." But I do want to address that first because I think there's enough record evidence and based on the case law that this court can even come to the conclusion that she was not speaking primarily as a citizen.
She is the president of the union,
Correct.
and the lead negotiator to get the hazard pay with her was, what's his name?
Stringer.
And she's a bus driver. You wouldn't normally think a bus driver would go speak to the CEO. But when she does, she's going during the hours that she did her union work. And according to her, she didn't use the profanity, but she did say she was going to go to the board. That, if those facts, as asserted by her, were true, do you have any argument that this doesn't relate to union speech?
Yes, Your Honor. That kind of combines a couple of different factors.
Well, it combines all the facts that she's pointing to and asserts. So if we put aside the forfeiture question, you're still saying that under our law, Supreme Court law, Bodie, that those facts asserted by her don't even give you a fact dispute as to a matter of public concern?
No, Your Honor. We dispute that. So on whether or not she's a citizen or not, speaking primarily as a citizen, this court has looked to factors such as whether the speech was internal, whether or not the speech related to knowledge gained through the employment relationship, whether or not it was made up the chain of command. Those all go to citizen, whether primarily as a citizen or not. Public concern elements aside, which I will get to, but just to focus on the citizenship.
Why don't you start with what the district court found? He assumed citizen. So let's start with how it could not be a matter of public concern, union association, if the union president uses one slang word when she finds out that the person, the COO, that negotiated all the hazard pay for the union members, she finds out he's fired. And she says, bitch, and says, I've got to go to the board. How is that about a personal grievance?
So that gets into Waters. So much of what you brought up is her version of the events. And
But I'm just asking you, if he's going to stand up and say that they did challenge the investigation, would you agree that just on the facts supported, we have a question of fact, not an issue of law?
Your Honor, I disagree with that because based on Waters and Heffernan,
I know.
they say that you can't, the process that the court must go through is that we look to whether or not if there's a dispute as to what was said, which much of what you're saying is, well, based on what they said, I'm going to the board and I didn't say bitch. If there's a dispute, we have to look at the court would defer to the employer if the employer reached that determination reasonably.
That's the forfeiture argument.
So,
Lurking in this case, as he says in the statement of facts, is disbelief about this investigation. In other words, if you really want to talk about the investigation, even if they don't cite salvage, it sure looks like this is deficient in terms of a reasonable investigation. You're shaking your head, but the guy immediately after one slang word, the CEO says, fire her for insubordination. Within an hour, that's your investigation time, she shows up. And under salvage, we're expecting the employer to say, well, what do you think you said? But instead, they've got a pre-printed, you're fired.
So, Your Honor, on the reasonableness of the investigation, if we're even getting there.
Well, you have to get there if you're going to rely on Waters. You've got to get there.
Well, Your Honor, I think this case, based on the facts, is even distinguishable from Waters, and even all the cases that look at reasonable investigation are situations where there was a speech made and the decision maker is unsure of whether or not employee A or employee B is to be believed. So then we go in and do a reasonable investigation and then make our firing decision based on that reasonable investigation. Here we have the actual decision maker has firsthand knowledge of what was said, was a firsthand recipient, heard with his own ears what was said. I think that is even distinguishable from Waters in every single case.
Or he made it up because he doesn't like this union president.
Your Honor.
The opposite view, and no one's even asking her, is there an opposite view? Bus driver for 30 years fired for using the word bitch?
Your Honor, I think that when you're looking at the reasonableness of the investigation, the employer, much deference is given to the employer. I think the Supreme Court kind of repeatedly says and guides the lower courts to say we're not here to second guess employment decisions of the employer decision if there was a reasonable determination here. That is.
How do you distinguish salvage? How is this a reasonable investigation when in that case it wasn't?
Well, in Waters, Your Honor.
Salvage. I said salvage.
Yes, but that salvage gets into.
I'm asking you to distinguish salvage. Don't go to Waters. Distinguish our authority and salvage. How is that? How is this case a reasonable investigation applying that authority?
Your Honor, I'm referring back to Waters because in Waters they also looked at the reasonableness in the investigation. In Waters, the court determined that it was reasonable even though they didn't speak to the employee pre-termination, didn't get her side of things. And
interpreted Waters in salvage. And we specifically said you've got to ask the employee what she said.
Well,
isn't that right about what the salvage stands for?
I think, Your Honor, that it's distinguishable here because we have firsthand knowledge of what was said. I don't think there's a...
By the antagonist, by the one who fires her.
By the decision maker in the case, which every other case out there, it's not the same fact pattern. There's a fact pattern of there's a dispute among employees or among the speaker and someone else as to what was actually said. Here, the case is different, Your Honor, and I think it's distinguishable on that grounds alone. And here, much like Waters, Ms. Jefferson was able to go through a grievance process after the fact to get her side of the story out there and go through the union process, which...
So, my best friend, he's fired, and I ask, is he really fired? My boss says, yep, and I just turn, no physical contact, no disruption. I just go, bastard, bitch. And 30 years of employment, she's fired.
Your Honor, the public concern element is not met here. Plaintiff is trying to make this into a labor case to say that because she's a union officer, somehow anything that she says is blessed with public concern activity.
Union president who negotiated with the person who's fired all the hazard pay these bus drivers got during the hurricane. Sounds like a union matter to me.
I encourage the court to look at what was actually said.
According to
the CBA was never mentioned. The hazard pay was never mentioned in the conversation. I don't think that's disputed. There's no dispute. Ms. Jefferson herself doesn't say, I said, what's going on with the hazard pay? It's not what happened. She asked if a single non-union employee had been terminated. When she was displeased with that response, she responded with bitch to her CEO. That's the facts of this case. She was asking about a...
Mixing and matching. You're assuming Wiggins's facts. You're not accepting hers. She said, I'm going to the executive board, and she didn't say bitch.
That, Your Honor, I think based on Hefferman and Waters, this court is guided by that to accept the employer's determination of what was actually said. And even if you don't take that, it's undisputed that Jefferson did not mention the CBA or did not mention union pay. She asked about a single non-union employee. So even if this person was fired, because he was non-union, she had nothing to do with that.
But he's
She
the
couldn't.
lead negotiator with her. He's the COO. She hears the whole guaranteed pay is in jeopardy. She thinks, well, we've got a guy I spoke to face-to-face that guaranteed it to me, goes to the CEO, and, oh, he's gone. Might create a little worry inside the union that the rumors are true.
Your Honor, I think the other factors here in play weigh more in favor of finding that this was an up the chain of command situation. We cite to in our brief the Wilson versus Trey case, which was a case of a similar nature where we have an employee who had concerns about video recording taking place in the sheriff's office. In that case, the deputy brought it up to the sheriff, the DA, Internal Affairs, and State Police. Summary judgment was granted in the trial court, and this court, with Your Honor writing the opinion, determined that that case was an up the chain of command situation, and the deputy was speaking as a citizen. I think in that case, one could argue there was even more elements at play, that he went outside of the chain of command to go outside to the DA and the state police, yet the court still found it was, you're speaking as an employee, not as primarily as a citizen. Here, the only speech is internal to the CEO. There's no public speech. There's no publicized speech. I think those factors weigh in favor of finding that this is a situation of an employee speaking not primarily as a citizen and not primarily on an issue of public concern. Those are factors I think that weigh in our favor. I would point to I think the key holding for the district court. I disagree. I think the key holding of the district court is found on 1913, where the court held, inquiring about the termination of Stringer, a single non-union employee is indicative of a personal disagreement with management's personnel decisions and does not suggest that the content of Jefferson's speech touched on a matter of public concern. I completely agree with that determination by Judge Afric in the district court.
That's after he applied Waters, right? That is after. I mean, this isn't a hostile question. That's Afric saying, if I'm accepting Wiggins' version of facts, it sure looks like a personal grievance.
Which I think is required of this court. Respectfully, I think that Waters and Heffernan requires this court, when there is a disagreement as to what was said, to apply Waters and Heffernan. And even jumping to the association claim, because I've kind of jumped around a little bit, but even on the association claim, Heffernan was an association claim. And so even the court there applied the Waters test and held that it's the employer's motive, and in particular the facts as the employer reasonably understood them that matter. So even on the association claim, where I know the Fifth Circuit has said we're not going to really look at public concern on the association part of it, Heffernan was an association claim and still applied the Waters test, saying that we have to defer to what the employer understood and reasonably believed the facts to be. So even on the association claim, this court is still obliged to look at the facts as the employer understood them, and it's just simply not enough to say, well, we have a dispute as to the facts, therefore summary judgment's inappropriate. When you have a dispute as to the facts, the Supreme Court has instructed us to apply that kind of Waters and Heffernan test. And to get to Pickering, I think I would stress to the court that you only get to Pickering if you jump past citizen and jump past public concern, which I think in the record, I think there's enough to say she wasn't speaking as a citizen, and enough, as Judge Afric found, that it was not a matter of public concern. So you have to jump those hurdles before you even get to Pickering. Once you get to Pickering, the weight on either side is not heavy, but it weighs in balance of the RTA here. The Supreme Court has kind of instructed, and I think this court as well, that the employer is consistently given substantial weight to where an employer's reasonable prediction of disruption, and that's what we have here. I know the counter argument as well, there wasn't much disruption, but I think that gets to the point originally that it was just an internal personal dispute in the chamber of the CEO.
In this record, certainly no threat, even though the notice to terminate says threat. What you've got is arguably a vulgarism, a single word vulgarism.
Correct, which would violate the policy in play for RTA. I don't think that's the respect or whatever the specific policy was that was cited.
Records say if anyone else has been fired for one utterance of profanity?
That may have been addressed in Mr. Wiggins' deposition, but I don't have that page cite or his exact testimony, but I think that question was posed to him,
And
Your Honor.
you remember his answer?
No, Your Honor, I don't, I'm sorry. I think that question was posed to him. Perhaps my opponent would remember that. But I think on balance, even if we're getting to Pickering, the balance weighs in our favor, and the association claims much of the Pickering test is the same, so for much of the same reasons, the plaintiff can't establish the facts on the association claim. I'm going to end with
What's the status of the grievance? I mean, the woman was working for.
I do not know, Your Honor.
And she's exasperated, even if it's a friend being fired.
I have no idea about the establishment of the agreement. Page 14 of our brief discusses two of the Supreme Court, more recent Supreme Court cases that again have cautioned against turning these kind of basic employment matters into constitutional issues, including terminations or disagreement. I would just encourage the court that those are the cases that apply here, and on that basis, encourage the court to pray for the court to affirm the lower court's holding and affirm the summary judgment.
Thank you, counsel. Ms. Craig.
May it please the court. I'm Michelle Craig, appearing on behalf of Alex Wiggins, the CEO of the RTA at the time that this matter happened. The district court, in ruling on the freedom of association and speech claims, did not reach the issue of qualified immunity. While we ask that the court affirm the lower court's ruling, if the court is not inclined to do so, we remind this court that it may affirm a summary judgment on any grounds supported by the record, even if it's different from those relied on by the district court. Regardless, we submit that Mr. Wiggins should be entitled to qualified immunity from these claims. In Harlow versus Fitzgerald, when an Air Force employee sued two advisors to the presidency for conspiracy and wrongful discharge, the Supreme Court stated that public officials enjoy qualified immunity to the extent that their conduct is objectively reasonable in light of clearly established law. And as this court indicated in Harris versus Surpass, once a defendant raises such a defense, it is up to the plaintiff to rebut this defense by establishing that the official violated clearly established law. Defendant raised this defense in its answer and previous pleadings. Plaintiff appellant has offered no facts to establish that defendant violated clearly established law. Plaintiff appellant argues that Wiggins' beliefs regarding her behavior were not reasonable, believable, or plausible, but cites no cases to back that theory up. Per Harris versus Surpass, the court conducts a two-step analysis to determine whether a defendant is entitled to qualified immunity. Whether the plaintiff has shown that the official violated a statutory or constitutional right, and whether the plaintiff has shown that the right was clearly established at the time of the challenged conduct. For all the reasons set forth by counsel for the RTA, plaintiff has not established any statutory or constitutional violations. Further, plaintiff appellant has not set forth a right that was clearly established. This court in Hopkins versus State held that clearly established means at the time of the action, the official clearly understood that he was violating the law.
Would you agree that if her version of facts were true, so no profanity, just I'm going to go talk to the executive board of the union about this, there'd be no qualified immunity?
I would not.
He said, right after she said that, I'm going to the union executive board, he emailed and said, fire her.
I would not agree with that. Because the question becomes, why would she be going to the executive board for the firing of a non-union employee? She does not talk about the CEA. She does not talk about the pay contract. At the time, the contract had been signed 3 days before. There is absolutely nothing on the record that shows why she would think that the contract was not going to be upheld. She says that there were rumors that she heard, which caused her to go up the chain, but we have no record of who started those rumors. We have record that she indicates that she talked to different people, came to Stringer and realized that Stringer was going to be fired, but Stringer was her friend, and Stringer was a non-union employee. The matter in front of Mr. Wiggins does not
He's the union president. The union is all bus drivers, right? It's
correct. It's my understanding, yes.
So she's trying to protect the interest of bus drivers. And they, only 3 days before this incident, that's when the guarantee gets firmed up. But it's very plausible that they'd therefore be worried that wasn't going to happen. And so she's doing her job during her union hours. She goes to see CEO, and her story is she finds out the person that she was confident would defend that hazard pay has just been fired. And she says, I'm going to the union board now.
Right, but she does not say, because I believe this contract is in jeopardy. There's no conversation with Mr. Wiggins that indicates that she actually believes the contract is in jeopardy. She simply says it's on now and walks out, or it's on now and I'm going to my executive board. But there's no facts to indicate why she would be going to the executive board, because from his point of view, he doesn't understand why she is in here in the first place if the pay contract has not been changed.
Yeah, I understand, yeah. Do you have any thoughts on waters and solids, or you weren't going to address that portion?
I had not plans to address that portion.
Your co-counsel wasn't sure what your client's answer was when he was deposed about whether anyone had ever been fired under this policy provision for a single vulgarism.
Correct,
Remember
and
what he
I do agree with him that I believe that it was addressed in the deposition. I actually thought about that because I did hear your question.
Yeah.
But I cannot say for certain what he said, so I don't want to make that assumption.
Thank you. The qualified immunity point is a strong point.
So the inquiry, according to this court, is that no reasonable officer could have believed the actions were proper. Plaintiff did not meet the burden that Wiggins violated any rights that were clearly established at the time of the challenged conduct, and has offered no case law that holds that a union's president's hostile, profane confrontation of an employer's officer regarding the termination of a non-union employee constitutes any clearly established right protected by the First Amendment. Further, there's no evidence in the record.
Your time has expired. I'll give you a moment to sum up.
Okay, there's no evidence in the record that Mr. Wiggins believed that the termination was unlawful, that the termination was unconstitutional, or that he did not believe that the behavior violated the code of conduct. Because the proper inquiry is what Mr. Wiggins believed at the time he made the determination, he should be entitled to qualified immunity.
Thank you, counsel. Rebuttal.
Thank you, Your Honor. Paragraph 48 of our statement of facts in opposition to second motion for a summary judgment is that Wiggins acknowledged no instance of an employee being fired for using profanity before. I went back and looked at our brief opposing the second motion for summary judgment, and I did not find the word investigate in it. So to that extent, Judge Afric was correct that we didn't have a full-blown Waters v. Churchill analysis of the reasonable investigation. But what we did do was we argued it factually. And we set out all the facts of, as previously cited to you, and I can do it again if you want, showing the facts that show that the investigation was not reasonable. And we also argued, if you recall, that there was a fact dispute that precluded summary judgment. So we did address that issue through the guise of, here's the facts that show it wasn't reasonable, and there's a fact dispute such that it has to go to trial.
Do you have record sites for where you contested the factual conclusion that the investigation was reasonable?
Page 8 of our brief is the best statement of the argument, other than in the statement of the facts.
You're saying page 8 of your appellate brief?
No, page 8 of our opposition brief to the second motion for summary judgment. It's document 95 in the court below, and document 95-1 is our statement of facts in support of that. And
You're saying there you told the district court that you believed the investigation was unreasonable?
we set forth the facts that show the investigation was unreasonable. We did not come forward and say.
What do you mean when you say set forth the fact? That's the fact section of your brief?
In the statement of the facts, and also in our
There's
separate.
no argument. I take your point then. It was plenty of stuff in the facts that says the investigation was not a good investigation.
Yes, but we
There was
did.
never any, but as far as you know, it wasn't part of the argumentation.
Correct, Judge. In this court, that was most strongly addressed in our reply brief in response to the defense raising that issue in their response.
This court, right, but we're asking about the district court.
Okay, yes. So Judge Afric was correct that we didn't have a full-blown Waters analysis showing that applying the law to the facts as to why the investigation was unreasonable, but we did have all those facts in there, and we did say that there was a fact dispute.
But then when you come up appealing his order in the principal brief, you don't attack it there either.
We viewed, as I argued before, we viewed the linchpin of the judge's decision to be the application of the Pickering test. And I'd also note that this issue kind of snuck into the case on the second summary judgment briefing. If you read Judge Afric's order dated December 7th, 2022, where he gave them a second bite at the apple, this is after we'd had the final pretrial conference and after the case was set for trial, and he continued the trial, and he entered and continued the trial. It was initially because they hadn't briefed the issues of qualified immunity prior in their first shot at summary judgment. And he was giving them another bite at the apple because he wanted to clean up the record. That's my suspicion as to why. He wanted a clean trial record. He didn't want loose issues hanging around. And at the end of that, he says, and you can go ahead and rebrief summary judgment on the merits also. So that's some background, and you guys are judges, I'm not, so you might have more insights into why Judge Afric's doing something that I don't have. I may have some other ones, but that's not for today. I'd also note that under this court's precedent in Coin v. Haney, 306 F. 3rd, 268 at page 274, a Fifth Circuit case from 2002, when you get to the Pickering balancing test, once the employee has shown that there's a public concern, which in this case would be the association and speech related to union activities, the public budget, public service, all those things that Janice tells us are public. Then it's the employer who bears the burden to establish that its interest and efficiency outweigh the plaintiff's right to speak. So it's a burden shifting thing. Once we come forward, private citizens speaking on a matter of public concern, which I don't think there's really any doubt that she was speaking as a bus driver. Bus driver's job isn't coming into the CEO's office to talk about a pay agreement. She was talking as union president. Public concern, it's the hurricane pay agreement. It's a public sector union agreement. That's a public concern. Judge Afric said it was a weak public concern. There's some tricky Fifth Circuit case law when you look at the cases in the pattern jury instructions for this type of case between Body and Kinney about whether it's a question of law for the court or a mixed question of law of fact under Kinney, such that I see my time is up. May I take 10 seconds just to conclude?
Absolutely.
Kinney says it's mixed question of law of fact, which under U.S. Supreme Court precedent would say it goes to the jury. So with that, thank you for your time, Your Honor.
All right, thank you, counsel. All right, the court will take this matter under